matter of the Institute and Faculty of Actuaries and
Yes.
My lords, my lady, I appear for the appellant, Mr. Davda, in this appeal. My learned friend, Mr. David Reed, leading Miss Joanne Connolly, appears for the respondent. My lords, my lady, can I check that you have 3 bundles, which should be the core bundle, supplemental bundle, and bundle of authorities?
Yes.
And added to that, I hope, has been an additional authority which the court alerted the parties to overnight.
Yes.
Before I...
Yes.
This is an appeal, as you know, against the judgment of the Employment Appeals Tribunal of the 12th of May 2023, in which it allowed the respondent's appeal in respect of a claim of direct discrimination.
Yes.
Before I go further, there's just one matter which I want to alert the court to, which may affect the order that the court produces at the end of this appeal. And that is this: as you will have seen from the papers, the current position is that the Employment Appeal Tribunal have remitted the Section 19 claim and the Section 112 claim to the Employment Tribunal.
Yes.
If this appeal succeeds in its entirety, the Section 19 claim will fall away. It's an alternative claim. That would leave the Section 112 claim to be resolved by the tribunal. The appellant has indicated that if that is the result, in other words, if this court upholds his appeal and restores the tribunal's decision on the direct discrimination claim, he will no longer seek to go back to the tribunal on the Section 112 claim.
Thank you.
Because essentially the remedy is the same. So the order which we would be seeking is that this matter be remitted to the Employment Appeal Tribunal to deal with the remedy appeal which is outstanding.
Thank you.
Clear.
Yes.
I ought to say just a reservation on that. If this appeal were to go to another place, that obviously would revert to the position as before. But that's the preliminary matter. In relation to the appeal generally, I'll refer to the parties as the claimant and respondent as below. I propose to deal with matters in the following order. I'll undertake an overview of the case and appeal relatively briefly, unless you won't be assisted by that. I'll then go through the central findings of the Employment Tribunal relevant to this appeal. I will then take each of the grounds of appeal in turn. This court is primarily concerned with the decision of the Employment Tribunal. Insofar as the Employment Appeal Tribunal's reasonings are relevant, I will deal with those when I deal with the grounds of appeal.
Thank you.
So dealing first with the overview.
Yes.
Much of this will be familiar to you from reading the paper, so I'll take it relatively quickly. The respondent is the regulatory body for the actuarial profession in the United Kingdom. It is the body responsible for setting, conducting and marking the examinations necessary to become a qualified actuary and a fellow of the Institute. It is a qualifications body within Section 53 and 54 of the Equality Act. To become a fellow of the respondent, which is the highest actuarial...
Is it a statutory body or is it just...
No, it's not a statutory
Right.
body.
So it's acquired all that by just being?
Yes. In fact, from recollection, an actuary is not a protected designation.
Right.
Although people know, unless you're regulated by the actuarial profession, you're probably not going to get very far.
Yes.
Calling yourself an actuary.
Thank
I'll
you.
be corrected by my learned friend on the other side if I'm wrong about that, but that's from recollection. To become a fellow of the respondent prior to the 31st of December 2018, it was necessary to pass 15 examinations, made of 9 core technical examinations, 3 core applications, 2 specialist technical subject examinations, and 1 specialist application. This is all set out in the judgment you've seen. The respondent is one of several leading global regulators. That is, the regulators who set the standards for the actuarial profession across the world. And it recruits student members both in the UK and overseas. And in 2017-18, in its annual review, it showed that it had slightly more Indian students than those from the UK. And there's a document in the supplemental bundle at page 29 which illustrates that. This is a
But when you say one of several leading global regulators, they're not. I mean, they're global regulators by reputation.
Yes.
They don't have any global standing. So
No.
it's simply because of the quality of the exams and everything else that if you become a fellow, that will be recognised as as having value globally.
Precisely. They're not. There's no global standard, but
No.
there's 3 or 4.
And there are a number of others. I mean, I've seen there are 2 in the USA, or was one in Canada, I think.
That's
isn't
correct.
There? One in India, one in Australia, one in Switzerland, presumably elsewhere as well.
Yes, most countries. There's one in South Africa, for example, as well. But the leading ones are those in the United States, Canada, and the United Kingdom. I understand it.
Right.
Well, when you say leading, what do you actually mean
Well,
by leading?
When they, as I understand it, and this is to some extent dealt with in the judgment, the position is that when actuaries are being employed across the globe, those are the most attractive qualifications to
People
have.
regard being a member of that body as being a good thing in employment terms, because
Yes.
you're likely to be somebody who has good, high standards.
And there was evidence before the tribunal which showed that Mr. Davda, the claimant's employer, particularly, for example, paid people more if they had the qualification from the respondent than they did if they had a European qualification, for example. There was that. So that's the sort of view that the profession takes as a whole. I put it no higher than I'm just making that point.
Sorry, I forgot which page. It was.
Page 29, the supplemental bundle. This is an extract from the 2017-18 annual review, and you'll see it identifies 16,000 student members and gives an indication in the box below the circles that it had 5,854 from India and 5,618 rather from the UK.
So is that on page 29 of the supplementary bundle? The replacement supplementary bundle?
It should be.
This thing.
Where does it say how many Indian students there are then?
In the circles in the box.
Oh gosh.
You might not. So I'll read it out because.
No, I can see it now. I hadn't even seen the words that even the numbers. But I've got it now.
I've left my glasses in my room. So.
Sorry, the box it says the left-hand circle, the large circle says India.
Yes.
5854.
Yes.
And the other large box says UK 5618.
And then the others are much smaller.
China, Kenya, South Africa, and Ireland are also mentioned.
Yeah.
That we would say is not coincidental. It feeds into the issues in this case.
There are 155 exam centres.
Worldwide, across the world.
Thank you.
The respondent has mutual recognition agreements with different actuarial regulators in other countries. And there are essentially 2 types of MRA. The first type is where a student member of the respondent has sat an examination with an overseas regulator, and the respondent recognises that exam result by exempting the student from the equivalent exam in its roster examinations. The second type of MRA is where there is an actuary who is qualified overseas, fully qualified, joins the respondent, and the respondent recognises their full qualification and appoints them effectively as a fellow of the respondent.
So whatever they're called under the other system, maybe fellow, maybe something else, that's treated as entitling them to become a fellow.
Yes, that's right. That form of MRA was common when we were in the European Union because it would...
Probably had to.
Yes, that was part of the single market
Yeah.
provisions, that you would recognise each other's qualifications, and that was... The claimant was a student member of the respondent, and still is. He is a UK national working in Switzerland. It's not in dispute, and the tribunal made this finding. The examinations of the respondent are exacting, the pass rates are low, and it's not unusual for students to sit the exams several times before passing them. The respondent holds examinations twice per year, once in April and once in September. In the period with which gave rise to the claim, the claimant was becoming increasingly frustrated by two matters which he regarded as both unfair and discriminatory. First, he became aware that Indian student members of the respondent were able to sit its exams, but they could also join the Indian Actuarial Association, the IAI, and sit its examinations. And if it passed with the IAI, it would secure an exemption from the respondent for the equivalent examination. Now, the IAI is provided with its textbooks by a connected company to the respondent. It has exactly the same curriculum, it has exactly the same course material, and it has the same, although not identical, exams, in the sense that the exam paper is not identical, but it's taught to the same curriculum. The IAI, again, we'd say not entirely coincidentally, has its exams 1 month after the respondent's exams. So the first exam for the respondent is April, the IAI is in May. The second exam for the respondent is September, the IA exam is in October. The effect of that is that the Indian student member of the respondent, an Indian national who's joined the respondent as a student, can revise, for example, for the CT1 exam. He can sit that with the respondent in April, see how it goes, and he can sit the same exam, not the same paper, but the same exam in May, because he can do that through the IAI if he joins the IAI. The second frustration, I'll mention this briefly because it doesn't feature in the appeal, of the claimant came about from his work in Switzerland, and that is that he believed it was easier to become a fully qualified actuary in Switzerland than it was through the respondent's route, and he saw colleagues of him, his Swiss colleagues, doing that and then becoming appointed as fellows of the respondent by cross-qualification in that way.
They qualify in Switzerland and they're recognised as a member of the Institute
fellow
in
of
the United Kingdom.
Yes, that gave rise to his indirect claim 3. Now, those two matters coincided with the respondent changing its curriculum at the end of 2018.
So do we know if the appellant can become a qualified actuary in Switzerland, or do we not know?
We do. That was dealt with in the hearing below, and the short answer is no. His German isn't sufficiently proficient, but apart from that, there is no impediment.
There's no nationality requirement, there's just a language competence requirement.
Yes, it's a highly technical language requirement, as you would expect when you're dealing with an actuarial profession. That is why that claim was brought only as an indirect discrimination and not as a direct discrimination claim. Those two matters coincided, or the claim's frustration rather, coincided with the respondent changing its curriculum at the end of 2018, the effect of which was that under the new curriculum, in order to be given a pass for some of the exams under the new curriculum, you had to have passed 2 exams under the old curriculum. And if you'd only passed 1, you lost the benefit of the one you'd passed. Mm-hmm. You had to take the whole new exam again. And that affected the claimant. It's set out in the judgment, but there were 2 exams into the new curriculum, the CM1 and the CS2, where the claimant had 1 qualifying exam but not the other. So he stood to lose the benefit of the work he'd already done. All of those facts gave rise to 4 claims in the tribunal. sorry, there's one factor I've not mentioned before I get to that. It emerged through the claimant's inquiries that the respondent had reached an agreement or understanding with the IAI that the IAI would not permit British students to become members of the IAI. That's the way it was put by the claimant, and there was certainly evidence which the tribunal made the finding to support that. I'll come to that in more detail when I deal with ground 4. But all of those facts gave rise to 4 claims. The matter relating to Indian students having additional opportunities to pass exams gave rise to a direct claim, claim 1, and an alternative indirect claim 2, both race in brackets nationality claims. The facts relating to the recognition of the Swiss qualification gave rise to an indirect discrimination claim, claim 3, and the facts relating to the agreement between the respondent and the IAI gave rise to a claim of instructing, causing or inducing discrimination, claim 4. The tribunal upheld claims 1 and 2, despite them being alternative claims, and also claim 4, but dismissed the Swiss claim, claim 3. The respondent appealed the outcomes in claims 1, 2 and 4, and the claimant cross-appealed claim 3. The Employment Appeals Tribunal, in judgment of the 12th of May of last year, dismissed entirely, allowed the appeal under claim 1, dismissed that claim entirely, and it remitted the indirect India claim, claim 2, and the causing or inducing claim, claim 4. It dismissed the claimant's cross-appeal, the Swiss claim, claim 3. As I've said, that means that as matters currently stand, 2 claims are on their way back to the tribunal, the Section 19 India claim and the Section 112 claim. But as I've indicated, because this is an alternative, the direct claim is an alternative claim, the Section 19 claim will fall away, which would only leave the Section 112 claim. But the claimant has indicated, and I've told this court that will no longer be proceeded with. So this appeal is concerned with claim 1, the direct discrimination claim, and I make it clear that it's been the claimant's primary case throughout that this is a direct discrimination as opposed to an indirect discrimination. They're brought as alternatives for the obvious reason that this is not entirely clear in terms of the usual way of bringing a discrimination claim where you have an obvious discrimination in the sense of the comparator treatment. I'm now going to turn to the relevant findings of the Employment Tribunal. I'd ask you to start, if I could, at page 85 of the core bundle. I'd invite you to note the agreed facts, which were the facts agreed in halfway down that page.
Yes.
Then moving through the judgment, next paragraph 10 on page 90. I'm mentioning this, I'm not going to deal with it at this stage, but this section deals with an application to produce further evidence. I mention that because it's relevant to ground 4, and I'll deal with it then. But I just invite you to note that that application of the respondents was refused and there was no appeal against it. Then moving through to the findings of fact, which start at the top of page 95. 35 through to 38 summarise the exam system, which I've outlined a moment ago. I draw your attention to 37, which deals with the point about the new curriculum and the losing of exam passes. Next, at 41, it was not in dispute that this is page 96,
Yes.
paragraph 41, not in dispute that the IAI follows an identical syllabus to the respondent, uses the same education materials and sex examinations that are directly equivalent to the respondent's examinations and which are structured in the same manner. Clearly, each individual examination is unique, but not in dispute that a person who followed the respondent's syllabus and teaching materials will be able to sit an equivalent exam set by the IAI. And there was a direct correlation between those exams and those of the respondent. Paragraph 42.
Right. The exams that the Actuaries of India Association set are exams to enable somebody to become, whatever the phrase is, a fellow of the Institute of Actuaries of India, is it?
That's correct.
Yeah.
The next paragraph, paragraph 42, sets out the MRA that the respondent has with the IAI, whereby it recognises passes of the IAI as direct equivalents of passes in the respondent's corresponding exams and grants an automatic exemption from the respondent's corresponding examination. (44) The exemptions granted for the IAI exams cover all examinations required to become a fellow or an associate of the respondent, apart from one. I think in my skeleton I've said all exams. I'm corrected on that by the respondent, they're correct. So of the 15 exams necessary to become a fellow of the respondent, they give exemptions for 14 exams. There's one that they don't give an exemption for. That's a specialist application exam, which is the reason that is not an exemption is not given to that because it's in a sense a UK specific exam. It's an application that you'll need in this country. (47) rather, deals with what I've outlined already, the setting of the exams and the sequencing of those exams. So twice a year, not on the same day. The respondent has no bar to membership from students from other countries. This means that Indian nationals who are members of the Actuaries of India can also become members of the respondent. They can sit 2 examinations per year under the IAI exam timetable and 2 examinations per year if they wish under the respondent's exam timetable. That means Indian students can sit 4 different examinations each year, all of which would, if successfully passed, be counted directly or by exemption towards.
2 will count because they're taking the respondent's exam. 2 will be treated as equivalent and they'll get exemptions.
Exactly.
Yeah.
But the real feature is the doubling up of the opportunity. So you can revise for a CT1 exam, as mentioned in April, and you can.
And if the Institute of India continues to offer 2 exams in 2 months, close to the other ones, that may be beneficial. If they don't,
well,
then they wouldn't have 4.
Well, they do. They every year.
They do, yeah.
They offer, yes, they offer, yeah, exactly. They every year they offer 2 exam sittings. The student chooses the exam they want to sit. I want to sit CT1 in April with the respondent. I want to see CT1 in May with the IAI.
Yeah.
They can do that. Next, paragraph 50, and this, I'm not going to deal with this in detail at this stage because again it's relevant to ground 4. But in this section of the judgment, the tribunal deal with the agreement between the IAI and the respondent. I just mentioned at this point, I'm going to come back to it, that you can see this runs from paragraph 49 through to this section that is, through to paragraph 81, where we submit that the tribunal grappled with the evidence and reached findings of fact which it was entitled to reach on the evidence it heard. And it reached findings of fact at 72 and 73 that there was an agreement between the respondent and the IAI, or an understanding rather, not an understanding that the IAI would not admit UK residents and citizens and would not allow UK residents and citizens to sit the examinations through the IAI in the UK. And then, paragraph 80, the tribunal found as a fact that the IAI does have a policy of not allowing UK nationals to join it, and this policy was also applied to the claimant when he tried to join in 2017. I'll come back to that, as I say, in more detail when I deal with ground 4. Next, and just to mention, the section beginning on paragraph 113 sets out the law. There is no criticism of the tribunal's directions on the law in this case. And then paragraph 130 onwards deals with the findings on the claim that is subject to this appeal. That's page 110.
Yes.
Paragraph 130 sets out the claim, and then 131 deals with the comparator. That features in ground 3. The claimant relies on a hypothetical Indian student member of the respondent. He contends that the hypothetical Indian student is in a materially same circumstance as the claimant. The respondent challenged that, saying it wasn't the correct comparator. 132, the tribunal accepted the claimant's position that he was entitled to choose his comparator and that it was an appropriate comparator. At 134 and 133 deals with less favourable treatment. Claimant contended he was treated less favourably than the Indian member because the Indian member had the opportunity to join the IAI and sit exams, and this is the crucial part, which were recognised by the respondent through exemptions, whereas the UK national did not. And then 134 repeats the findings in relation to the exams being equivalent, and that the respondent recognised the equivalent pass of the IAI examination. 136 finds exact correspondence between the protected characteristics of nationality and the reason for the treatment, that is, membership of the IAI. So that is a central finding which is the subject of ground 2. (137), the respondent had argued that the claimant's claim was not properly against it, but against the IAI, because it was the IAI and not the respondent who treated the claimant less favourably. The tribunal rejected that and found the respondent, by automatically giving exemptions for IAI exams, which he treats as directly equivalent, and passing the exam effectively means passing the respondent's exam. And you can read the rest for yourself. In relation to that, paragraph 141, the tribunal reached its conclusion on that claim, upholding the claim by holding that the respondent treated the claimant less favourably than international when it gave exemptions for exams set by the IAI, because the claimant, who was a UK national, was barred from joining the IAI because of his nationality. That is the central finding on the claim. It is the finding of the tribunal on the evidence that it heard.
Is that the same or different from the judgment at paragraph 1 on page 83?
Well, the EAT have suggested it's different. In my submission, it's a distinction without a difference. They effectively mean the same thing. The wording is slightly different, but it doesn't. Nothing turns on that. The factual issue. The factual issue in this case is not difficult. The legal issues are complex. The factual issue is not difficult. The claimant's case is that he doesn't have the opportunity which his comparator Indian student members have. That is to get an exemption for exams sat by the II. And I'll come on to this in more detail, but just to note, that is a positive act by the respondent to give an exemption or not to give an exemption. That is something the respondent does. It's not something the IAI does. Before I come on to the grounds of appeal, there's just two other relevant findings. They appear in relation to other claims, but just to reinforce the point. Paragraph 152 on page 114, and this is within the indirect discrimination claim on the same facts. At 152, in the second part of that paragraph, it reinforces the same point that the claimant had tried to join the IAI, but his membership was rejected on the grounds of nationality. And at 154, findings that the respondent was aware of the policy of the IAI. Those are the findings of the tribunal. I'll now move to the grounds of appeal. I'll take them and I'll start with ground one. Ground one is that the Employment Appeals Tribunal erred in law in determining that the respondent had not subjected the appellant to less favourable treatment. And that is dealt with in the Employment Appeals Tribunal's judgment at page 68, paragraph 46. And at the end of this first sentence, the Employment Appeal Tribunal held, I do not accept that where the IAI or other organisations that have individual exam exemption arrangements with the respondent allow their students to undertake examinations, that is treatment afforded by the respondent.
Well, that's correct, isn't it?
We say it's not correct. The position here is not to focus on what the IAI did or didn't do. The position here is to focus on what the respondent did.
There are two separate states of affairs. One is the holding of examinations in May and October, and that is done by the IAI.
But then there's
The second separate thing, and it's an interesting question you haven't gone to the claim for, is a separate intellectual exercise where the respondent decides to grant recognition to certain exams. And they include the IAI, but if somebody took exams in Australia or South Africa, they would also recognise those too, wouldn't they?
Yes, that is something they do. And
so the exemptions, it's the system of recognition of exemptions that you're challenging.
Yes, it's the recognition of exams as exemptions for the existing respondent exams. That is the issue. Because, just taking a step back, if you have side by side a British student member of the IAI, of the respondent rather, and an Indian student member of the respondent, the British student member does not have the opportunity to get the exemption for IAI exams. The Indian student member has the opportunity to get the IAI exam exemption. That is something given to the Indian student member by the respondent. And that seems self-evident that it's the respondent's act. The IAI don't force the respondent to give exemptions. That's a voluntary act of the respondent. We will give you an exemption. And that is where the less favourable treatment. It's no more complicated than that. It is to say, you, the Indian student member of the respondent, are getting something which I, the British student member, can't get. And it's
important. And the only way that the respondent could eliminate that discrimination, presumably, is by refusing to grant an exemption, because they can't force the IIA to admit British nationals.
Yeah.
So the claimant can never bring about a situation where the respondent is required to have a situation where he takes exams by different bodies and accumulates those for exemption. All he will ever be able to achieve in these proceedings is to say the Indian students shouldn't have the opportunity to have exams taken by the AIA recognised.
Well, that's not entirely the position, because clearly it is a matter of negotiation between the IAI and the respondent. And it may be that one of the selling points for the IAI is that if you take our exams, you get exempted from the respondent.
But legally, the body that will decide whether to change its membership rules, whether for economic, moral, social or political reasons, will be the IAI.
Yes, but the respondent is not without power in this circumstances, because the respondent provides the entire syllabus for the IAI. It provides its exam curriculum, and it's open, or was open at the time, for the respondent to say, look, you'll have to start admitting British students, and if you don't, we've got certain things that we can do. As if that's
not to recognise the examination,
not recognise your exams. Now, that is not far-fetched in any way, because the reality is that then the best that any claimant could bring would be an indirect discrimination claim based on the difficulty of qualifying through the Indian route, which is what we have to do. But that, all we're looking at this stage is less favourable treatment, and there may be very good reasons why people are treated less favourably. It may be that they haven't been able to pass the exams when they went to join another actuarial body overseas, or it may be those exams there's demanding.
There's not less favourable treatment, oddly enough, by the respondent. The respondent gives 2 exam opportunities each year to people who are members. It's bizarrely more favourable treatment for Indian nationals, and possibly for nationals of other countries, because if they take exams for that body abroad, they may be recognised. So you may have 2 if you add India. If you go to Australia, for all I know, you might have another 2. If you go to South Africa as well, you might have 4, 6, 8, 10 opportunities.
But there's no evidence that the other actuarial bodies restrict their membership on nationality grounds.
Well, that's be your other point about is there direct correspondence, and you'd have to prove it was the same, that that there's a complete
Well, I'm going to come on to that.
But once you get onto the system of recognition, it's for you to prove that the system of recognition is the same as nationality. But that's your second
Yes,
point.
that's the reason why treatment. Just one point that's important to mention, and it's an obvious point, but I mention it. In order to get the exemption, the Indian student has to join the respondent. They don't get an exemption unless they join the respondent. So it's not as if the respondent just gives IAI students exemptions without bringing them into the fold, as it were. And just to finish the point off, that the granting of those exemptions is within Section 53 as being part of the arrangements the respondent has for conferring a relevant qualification. So just to finish the point in relation to the claimant's case, before I move to what the respondent said, is that we are looking here at the recognition of examinations as a positive act by the respondent, something which it makes available, in this case, the comparator being the Indian student member, which it doesn't make available to its British student member. The respondent says, and this is in their skeleton argument, paragraph 3.7, that the IAI's decision to permit or refuse to permit a student to sit its exams is not an exact action of the respondent. Well, we agree with that. It's not. But it's not the central issue. It is the respondent's decision to register exam passes for Indian members. That is not the IAI's decision. The second point raised is the tribunal was wrong to conclude that the respondent adopts the IAA exam results effectively as its own. And it refers to paragraph 137 of the judgment. It's worth looking at paragraph 137 in a bit more detail, because it's self-evident that what the tribunal say is correct. The tribunal has found the respondent automatically gives exemptions for IAA exams. That's so far so good. The IAA exams are treated as direct equivalents, and passing an exam effectively means passing the respondent's exam. That's correct. The tribunal finds the respondent adopts the IAI or the Indian exam results effectively as its own exam results.
What does that sentence mean? What they do legally is to say that if you want to become a member of the institute, the respondent, you have to do these exams. If you've done equivalent exams, which include the IAI exams, those will count as passes for the purposes of membership and fellowship of our institute. When you say adopt, what extra legal act other than treating as an exemption is involved?
Well, metaphorically what it means is the Indian student turning up at the office of the IAI, waving his exam pass, and then somebody in the office rubber stamping that and saying, yes, you're exempt from the equivalent exam.
Because it's an equivalent standard to the exams they would otherwise have had to take in England.
Yes.
But I don't know what the word adoption adds. It's simply a recognition that you've got to do X number of subjects and get results. If you've done the same subject in India or elsewhere, which is recognised as equivalent. So I don't see what adopting adds.
Well, what it means is if you've got 14 exams and you've taken 5 in the UK and you've come up to your 6th exam and you pass that in India, adoption simply means
Recognition.
Recognition. You recognise the exam. It's no more. As I said, this is not factually complicated in the sense that yes, the tribunal may have used that phrase, but it doesn't. One can see exactly what they mean by it. It's not complicated in that respect. It certainly doesn't mean what the respondent suggests in their skeleton, that the respondent is somehow involved in the process of the Indian examination system and has any sense of approval of how the Indian IAA deals with its own exams. Its act of less favourable treatment, we say, comes at the end of the process, once all of those exams have been taken and passed. The next point that's made in the skeleton argument at paragraph 3.10 is that the Employment Appeals Tribunal was correct to conclude...
So before you leave 137, is the next sentence actually correct? If the respondent thus provides 2 additional opportunities to pass its own examinations. Because it doesn't, does it? It provides an opportunity, in the way you put it now, for examinations which are IIA examinations to be recognised as equivalent.
Yes, but if you get those exams, you don't have to pass the same exams with the respondent. And that's what the tribunal is saying. That if you have got those, if you get 2 exam passes through those sittings, you don't then have to pass the equivalent exams with the respondent.
No, exactly. But it says it, the respondent, thus provides 2 additional opportunities to pass its own examinations. But we agree, I think, that it's not accurate to say that.
I mean,
legally, it's the opportunity to have examinations that are IAA examinations, but recognised as equivalent, leading to exemptions.
That's right, but it has the same practical effect. I think that's what the tribunal are focusing on here. The practical effect of this is that you have effectively got a pass for 2 of the Institute's exams. It's looking at this in a practical way as to what actually happens on the ground. And if you were looking at this from the outside as a layperson, looking at this particular part of the judgment, that would make sense, because that in practice is what the tribunal does. It may not be the legally correct specific analysis saying, yes, they give an exemption which has the effect of doing that, but that's in reality what happens here. That the Indian student waives his 2 exam passes and he doesn't have to pass the respondent's exams. The next criticism is that it says the Employment Appeal from Respondent, the Employment Appeals Tribunal was correct to conclude that the fact that a consequence of passing an IAI exam was that a student could obtain an IEE in respect of one of the respondent's examinations. This did not mean that it was the respondent who had permitted or refused the IAI to take the IAI exams or excluded them from any opportunity to do so. Again, we don't disagree with that, but it's not the point in issue in the case. The point in issue in the case is who registers those exemptions, and that is the respondent. The respondent then suggests there's been a shifting of the position on the case on less favourable treatment. And as I've said, this is not a factually complicated matter, but just to see how it has developed, I invite you to turn up the supplemental bundle at page 37.
Shouldn't you start with a claim form? What did you actually claim?
Well, the claim form is a very lengthy document. It starts at it starts at page 141.
And is the material part 157?
Yes, 157. But just before we get to that, it's right to say that this case went through a number of iterations through the process, and that an agreed list of issues was produced prior to the hearing, and there was no suggestion by the respondent that required any amendment of the claim or anything like that.
If you're going through it, it's best to start with the claim,
yes,
isn't it, to see what you were asking.
I fully accept that.
And is it 157?
Yes, it starts at 157, so we see there that the claim starts by bringing paragraph 2.11, the allowing the students 4 sittings per year for the same qualification, where the British students are only permitted 2 sittings. That's alleged to be an act of direct or indirect race.
And that's the claim that this appeal is about.
That's the claim this appeal is about. But then that that goes into more detail over the page. Under paragraph 4, the page 159, the race discrimination claim, making the point that the exam system is identical to that of the UK body, they share the same study material and so on, exam timetables don't clash. And then 4.12, the respondent confers membership to the IAI student members and permits them to sit the IAI exams. So the respondent's exams, rather. The IAI does not confer membership on UK nationals. Consequently, the Indian student members rather have 4 exam sittings a year, and the UK nationals have only 2 sittings a year. And then paragraph 4.2.1 deals with less favourable treatment during the transition period. And then moving on a few pages, page 162 deals with the indirect claimant and nationality. And then section 6, page 165, deals with the direct discrimination of nationality. Firstly, 6.11 identifies the protected characteristic as being race in brackets nationality. And And then 616 says, whilst this may seem like discriminatory behaviour by the IAI, the claimant has learned the respondents instruct the IAI to discriminate.
That's your 112 claim 4, isn't it? Is it?
Yes, that's right, yes. And then 618 indicating it's not possible for the IFI student, obviously means the British IFOI student, to take the IA exams. That's the way the claimant put his case when commencing proceedings. But as I said, the case was clarified. He was representing himself at the time. So that was a litigant in person's pleading, as I understand it. And then by the time we got to the tribunal, the case having been struck out and reinstated, the position was set out in the list of issues which were replicated in the tribunal judgment.
So, sorry, you were taking us to the supplementary bundle. Are we not?
Well, I was dealing with
I know you were. I know you were.
Now I'm going to take
and you say the list of issues in the. Do you want us to take us to that first?
Well, I'll take you to the as we're dealing with the point. I'll take you firstly to the list of issues, and that's set out at the bottom of page 84. And into 85, the first bullet point, what is the less favourable treatment by the respondent? The claimant's case is treated less favourably than an Indian member because the Indian member has the opportunity to join the IAI and sit exams, which are recognised by the respondent for which exemptions are given. And that was the less favourable treatment. Going to...
just trying to understand this. I started 84, claim 1. Has he been treated less favourably by R than an Indian national in respect of the number of opportunities to pass examinations? That's the starting point. And then, is that the overall claim? And then, are these bits, the comparator and the less favourable treatment, sub-bits of that?
Well, that's the sort of generic way of putting the claim in the first paragraph you've just indicated, but the different components of the claim are those set out in the sub-paragraphs, bullet points below. Okay. Who is the comparator? Then we identify the comparator. What is the less favourable treatment? Then that's identified in the first bullet point.
Is it a typo? And set exams?
Sit, should be sit.
Yes.
Going to the way it was put in the claimant's submissions below, in the tribunal that is, that's in the supplemental bundle at page 37. These submissions are the closing submissions drafted before all of the evidence was heard. So, and starts at paragraph 33 through to 35. And you'll see in the second paragraph of 33, Respondent also gives exemptions to Indian students in respect of examinations if those students are also members of the IAI and have taken IA examinations. It allows students who have sat IAA exams to sit the examinations with it the same year. The IAA does not admit British nationals. And then it goes on, paragraph 34, a British national who is a student member of R compares himself with a hypothetical Indian student member of R. The Indian student member of R has the opportunity, if he or she so wishes, to join the IAI, sit its examinations, and by doing so double his or her chance of passing the relevant examination, because if she passes the IA exam, she will be exempt from the equivalent examination of R. The British student does not have, it's treated less fairly, does not have the same number of opportunities. And then paragraph 35, it might be said the respondent is treating its Indian students, British students precisely the same. They can both sit its examinations at the same time. The fact that the Indian student has an opportunity to go on the II and sit examinations has nothing to do with the respondent. However, if the question is asked, what is the reason for the treatment? Why does the Indian student have 4 opportunities, the British student only 2? I think we've seen that Indian student's nationality plays a part. The Indian student has 2 other opportunities as a member of the IAI. As I've said, the factual issue, so far as the role of the respondent is concerned, is clear and undisputed, and it's simply they allow the exemptions for the examinations passed by the IAI. It's that which is the less favourable treatment, and it's really no more complicated than that. There is a danger of being distracted on this issue with what the IAI do or don't do. But in a sense, when we're talking about less favourable treatment, we're not making a judgment in a sense about anything. There may be very good reasons why people are treated less favourably. That's just an objective fact that the British student doesn't get that exemption opportunity. The real issue in this appeal is why that happens, and whether that's a direct discrimination claim as we say it is. And that comes to the next issue, which is ground 2. And I'll deal, if I may, unless I can assist further on the first ground, I'll turn to ground 2, because it's our submission that actually this appeal, the heart of this appeal is what turns up in relation to ground 2, because the less favourable treatment is we say, clear.
The problem is, if the less favourable treatment is now described as the failure to offer exemptions, you need not just to look at the IAI position, you need to look more generally, don't you? Because what you're complaining about is that they recognise certain exams. Why do they recognise certain exams? Because they are seen as equivalent. And then the question is that on grounds of race? You say, oh yes, look at India, but don't you have to, for ground 2, look at whether the recognition system coincides with nationality in all respects, not just in relation to one subset of the exams that they recognise?
No, I don't, my lord, and I'm going to meet that point head on, because we say that has been a fundamental misunderstanding of the Employment Appeal Tribunal in this case, and I'm going to start it in this way. The ground of appeal, just to deal with that, is that the Employment Appeal Tribunal erred in determining the principle in James initially did not apply because there was not exact correspondence between membership or non-membership of the IA and nationality. Now, what lies at the heart of this issue is the difference between indirect discrimination and direct discrimination. If we're looking at an indirect discrimination claim, the pool for comparison in an indirect claim and the groups by which exact correspondence in a direct discrimination claim are determined are not derived in the same way. In other words, they're 2 different creatures. You have pools for comparison in indirect claims, and you have groups of advantage and disadvantage in direct discrimination claims. They're not pools in direct discrimination claims. The reason they are different is because they serve completely different purposes. A pool for comparison in an indirect claim tests group disadvantage. It flows logically from the PCP. You say what the PCP is, and the pools for comparison flow from that PCP. So, for example, in this case, the PCP is all related to the respondents dealing with its exam system. So the pool for comparison was all student members of the respondent, the British student members on the one side and everyone else on the other. Now, it's right to say the Employment Tribunal got that wrong and the EAT corrected that. I have to say I'm to some extent to blame for that, because there was some perhaps dilution of that argument in my submissions below, which led the ET down that route. But we accept, and that's why that decision is not being appealed, that the appropriate pool for comparison in the indirect claim is the British students on one hand and all student members on the other. The groups which test exact correspondence in a James and Eastleigh direct discrimination case is not concerned with group disadvantage. Its purpose is to test the reason for the difference in treatment between the two comparators. So in a direct discrimination case, and I'll come on to illustrate this in shortly, but in a direct discrimination case, you have, in this case, British nationals comparing themselves, British student members comparing themselves to Indian student members. Those are the two comparator groups. There is no other comparator group. And therefore, the advantage and disadvantage groups that you're concerned with flow logically from the comparators you've chosen. They don't flow from the decision of the IAI not to admit British students. They flow from the comparators chosen. Now, the confusion in this area of law has arisen in this way because in most cases, comparators are binary, men and women. So if you look at the James case, the well-known the swimming pool case, all men, all women are within the group, or the two groups, because they're all affected by the particular rule. But where the protected characteristic is not binary, or may not be binary, then different considerations apply. So you can, in nationality cases, have both a binary and non-binary analysis. So you can say British students on the one hand, and or we compare ourselves to everyone else on the other hand. And if you do that, that's a binary choice. The groups, the two comparator groups will encompass everyone. But if you say, I'm not comparing myself to all of the students, I'm just picking Indian students, the comparator groups aren't binary because there are other people not within it. But that doesn't affect the group disadvantage that you're looking at, the disadvantaged groups. Who suffers the disadvantage and who is advantaged? British students suffer disadvantage, Indian students suffer disadvantage.
I thought that the James and Eastleigh thing was performing a different purpose. Section 13 says a person discriminates against another if, because of a protected characteristic, A treats B less favourably than A treats or would treat others. Now here, A, you say, is discriminating against your client because of a protected characteristic nationality. Now, when you look at what they do, what they seem to do is to recognise examinations that are equivalent to the ones that they set for the purposes of deciding whether to admit people as fellows of the respondent. And that doesn't seem to do with race. that, or nationality, that appears to do with equivalence, whether the exam they're looking at is as good as the one that they set. Then I thought James and Eastleigh and the other cases step in and say, aha, be careful. It might look as if it's nothing to do with race, but there might be a complete overlap, or one might be a proxy for another and they use different words. So in James and Eastleigh, it was retirement age. Well, nothing to do with it, sex. But it was to do with sex, because the retirement age for women was different from the retirement age for men. Now, in this case, once you have something that appears to be treatment on grounds of equivalence of quality of the examinations, you have to ask yourself, well, is that then a substitute, a proxy for nationality discrimination? And at the moment, I don't understand why, in doing that, you just look at one part of the recognition of exemption system rather than the whole of it, to see whether or not they really are operating a system of exemptions which is because of race, or whether they're operating a system of exemptions based on equivalence, but which, because of what, in this case, the IAA do, but not necessarily Australia or South Africa do, might affect one group.
The answer, my lord, to that point is this, that you don't look generically across the board at the exemption system across the board. You have to look at each exemption scheme independently. For example, if you take, I don't know if this is the case, but assume it's the case. If there's an exemption system for Australian student members, so they can join the Australian equivalent of the respondent and have their exam. And the Australian student sought to bring this claim. There's no nationality bar in Australia. Assume that's the case.
Say a British national could join the Australian.
The British national could join.
And the British one can get an exemption for an Australian exam.
So firstly, there'd be no less favourable treatment. You wouldn't get past that. But even if you somehow got past that, the reason for the treatment would be nothing to do with nationality. You just presume you haven't passed the exam. That's why you didn't get the exemption. There'd be some other reason related to. But you have to look at each. These are not generic. You look at each and you say to, in the case of the IAI exams, you say, well, why hasn't this British student member just gone and joined the IAI and taken exams? You could get the exemption and do it that way.
Because the IIA wouldn't let him.
Well, that's right, because they have a nationality bar. So the reason for not getting the exemption in that case, maybe not in others, but in that case, is based on a nationality bar. And that's why you don't look at them generic. It's exactly the same way that if you, just a better way of illustrating this would be, just assume, forget the IAI system of not allowing people in. Just assume that a British student member had sat all of the IAI exams, gone through the whole system, comes to the respondent's office, waves the certificate in front of the respondent and says, register my exam. And the respondent turned around and says, no, we're not prepared to do so. We only do it for Indian students. We don't do it for British students.
But that then would be direct discrimination.
Exactly. And what you're doing with a proxy situation is just going one step back. You're uncovering the true reason why the exemption can't be given.
But the question is that what the respondent is doing? Is that discriminating against another because of a protected characteristic? The answer is no.
Well,
or is it no?
Well,
because they are just saying, well, I'm sorry, you haven't got an examination here. Now, why haven't you got it? Because the IA won't let you take it.
That's no different than the swimming pool saying, we're sorry, you can't come in because you're not of pensionable age. Sorry, you have to pay rather because you're of pensionable age. It's literally, it's precisely the same analysis. The swim pool, a perfectly innocent reason, no motive for discrimination.
It's the third party, and it doesn't matter that it's the third party that does the thing that leads to it.
The third party did it and says, and so you go, so no, it's pensionable age, you've got to pay and you don't have to pay. It's exactly the same analysis. Leaving aside whether there was agreement or not, leaving that point aside, assuming the IA had no knowledge, sorry, the respondent had no knowledge of the IAI's procedures, but it transpired that there was a bar on British members joining the IAI, that precisely the same outcome would be reached. Knowledge and motive are irrelevant. The reason is that the British member cannot join the IAI. It's a nationality bar. So just moving through what we say is the correct analysis. So as I've said, it flows, the question of who is in the advantage group and disadvantage group flows from the comparator. And the other thing to note, and this comes out of the authorities, is that it will be direct discrimination when the advantage group and the disadvantage group are sealed, where there's no overlap between them. As soon as you get a member of the disadvantaged group in the advantage group or vice versa, it becomes an indirect discrimination. That's because you're looking at differential treatment between groups. But where the groups are sealed, you're just doing, in a sense, a like for like with each of the claimant and the comparator. So when we talk about exact correspondence, what is meant is exact correspondence between the advantage group and the disadvantage group and the protected characteristic. And in this case, there are no Indian student members in the disadvantaged group, and there are no British students in the advantage group.
No Indian students in the advantage group.
Disadvantage.
In the disadvantage group.
And no British student members in the advantage group. What I mean by that is no Indian student member of the respondent is denied the opportunity of going down the IAI route.
Well, there may be Indian students in the disadvantaged group because they may not have joined the IAA. They can put themselves in the advantage group if they want to by joining.
That's the point. They have the opportunity. It's about the opportunity. There is no Indian student of the respondent who does not have the opportunity, if they so wish, to go through the IAI route. Every British student is denied that opportunity.
Do we know anything about dual nationals, by the way, British and Indian nationals?
No evidence.
We've got no evidence.
No evidence on that. I don't even know whether Indian allows dual nationality. Many countries don't have it. It's important, and this is moving on to a different part of the analysis, it's important when we're looking at a James and Isley case to be clear what exercise the tribunal is engaged in. First, it's looking to see whether there's been less favourable treatment between one person and another. And then it's looking to see what the reason is for that treatment. And it's going behind the ostensible reason to identify the real reason. We're familiar with the facts of James. Perhaps I can illustrate this by an example which is slightly convoluted, but I hope it works. James was a case of sex discrimination. But supposing the swimming pool in James had a sign in the reception which says, members of this particular private club can come in half price. So instead of paying £5, you pay £2.50. An Indian national turns up to the swimming pool, he sees the sign. So that's good, I can go and join that private club and I'll get in half price. He goes to the club and he's refused entry, and they say, we don't accept Indian nationals in our club. He knows, because he's got a friend who is British, that they accept British nationals. He knows that for a fact. He knows there are plenty of British people in the club. He has no idea whether the club bars any other foreign national. He doesn't have any evidence of that. He brings a claim. He brings a claim against the club, and he brings a claim against the swimming pool. He brings the claim against the club. The club cannot defend that claim by saying, oh, well, look, we let other nationalities in. His comparator is his English friend. So that would be obvious direct discrimination. I, Indian, have been banned from coming to your club because of nationality. I point to my British friend, he's my comparator.
The point there is, the thing that is being tested is a rule that says membership of a private club. Here it's recognition of foreign examination.
This comes back, we're dealing there with the club. Don't forget, we now move to the swimming pool. He's also sued the swimming pool. I want to get in half price, you made me pay full price, and you said it was because I wasn't a member of the club.
Yeah.
I couldn't join the club because they've got a nationality bar.
Yeah, but the point is the swimming pool has adopted a rule which is expressly tied to the club. Here we're dealing with a rule that is tied to recognition of foreign examination.
Well, let's be clear, we're not dealing with a rule generally across the respondent. Every foreign regulator has a different MRA, a different agreement with the respondent. So we're not dealing generically where the respondent opens its doors and says, anybody in the world take these exams. You're dealing with specific agreements reached with specific regulators.
Well, do we know that? I mean,
yeah.
From the evidence, that's in the evidence, is it? Because
that's,
we know that they recognise certain examinations as exempt.
Yeah.
I don't think it matters, but do we know if it's because they do it or they do it in the form of an agreement?
It's
they
because
can do it without an agreement. It's
because they have an MRA. I'll find it in the judgment. It's because they have an MRA with...
I don't think it matters because they wouldn't have to have an MRA. They could conduct their own assessment of equivalence.
But it answers the point that my Lord's made, which is that, is this a generic? It's not generic in the sense that it's actually, it's specific. And if one uses the analogy which I've just made with the club, the swimming pool has an agreement with the club where it lets its members in at a discounted rate. It has no idea the club's operating a nationality bar. That doesn't matter. Once it's discovered that that's the true reason why you can't get half-price discount because you can't join the club, then that's exactly the same as the James and Eastleigh case. It's exactly the same. And we say we're in exactly the same position here. If one looks at paragraph 42 of the decision, page 96, this deals with the MRA with the IAI.
Yes.
So that's a specific reference to the MRA that the IA has with the respondent. Now, going back to ground two, which we're still on, the fallacy that we say the Employment Appeals Tribunal fell into in this case was thinking of a direct discrimination claim in the way that you think of an indirect discrimination claim. It was treating a direct discrimination in relation to saying that the pool didn't encompass everyone it ought to, because it was thinking in terms of an indirect discrimination claim. In the proxy rule that applies, as it's called, you simply look at the advantage group and the disadvantage group and say, in their case, is the apparent reason, or treatment rather, a proxy for the protected characteristic. If the reason encompasses both groups, in this case British student members of the respondent and Indian student members of the respondent entirely, and there's none of the disadvantaged group are within the advantage group and vice versa, then there's direct discrimination. I'm going to pick up the authorities now because the respondents have suggested the law has taken something of a turn which we don't accept. Certainly not one that matters. But if I could start with James and Eastleigh, I won't deal with this in great length, but the passage I'd invite you to turn up, it's in the authorities bundle, page 27. Paragraph E, or letter E. Lord Bridge here, after the indented passage, is commenting on the Court of Appeal decision. The fallacy which underlies and vitiates this is the failure to recognise that the statutory pensionable age being fixed at 60 for women and 65 for men is itself a criterion which directly discriminates between men and women, in that it treats women more favourably than men on the grounds of sex. This was readily conceded by Mr. Belloff and indeed is self-evident. It follows inevitably any other differential treatment of men and women which adopts the same criteria must equally involve discrimination on the grounds of sex. And then the next passage we say is important, as Mr. Belloff was again constrained to concede the council would certainly have discriminated in favour of women and against men on the ground of sex if they expressly made the concession of free entry to the swimming pool available to women aged 60 and men aged 65. And that comes back to the point that I made a few moments ago. If the claimant had been allowed to go through the IAI system, there'd be no nationality bar, he's taken the exams, he comes to the office of the respondent, waves his certificate from the IAI, and they had said, no, we're not letting you register your exam as an exemption because we don't do that for our British students, we do it for our Indian students only. That would have been clear discrimination. And what that passage shows is that you just look behind that and you say, well, why wasn't he able to go through that system and get to the position where he could waive his certificate? And because, critically, the IAI put in a nationality bar. I want to now turn to Preddy and Bull, which is featured in the respondent submissions in some detail. Just to remind the court of the facts of that case, the defendants owned a private hotel. They were Christians and believed that it was sinful for unmarried couples to share a bed. So they therefore restricted occupancy of their 3 double-bedded rooms to married couples. Actually, that's 211 of the authorities bundle. The claimants, who were of the same sex in a civil partnership, claimed direct discrimination on the grounds of sexual orientation. They did so on 2 bases. First, they said that not allowing an unmarried couple to share a bed was direct discrimination on the basis of sexual orientation. And secondly, that distinguished between marriage and civil partnership was direct discrimination on the grounds of sexual orientation. The claim succeeded on the second ground, but failed on the first ground. The first ground failed because the hotel did not allow any unmarried couple use of the double-bedded rooms. So there was no exact correspondence then between sexual orientation and the particular provision. This was the provision of exact correspondence was explored by Baroness Hale in the judgment. It starts at page 218.
Yes.
What Baroness Hale does here is analyses several European cases, which I'll come to in a moment. But by paragraph 18, she introduces the James and Eastleigh case. and said in the halfway down there was exact correspondence between the criterion and the protected characteristic of sex. And then paragraph 21, she deals with a test by the Advocate General Sharpston in the ECJ, which I'm going to come to in due course. She said, by applying this not exact correspondence between those suffering the disadvantage of being denied a double bed.
Sorry, where's this?
Paragraph 21.
Thank you.
Being denied, and those enjoying the correlative advantage of being allowed one with the protected characteristics. While all same-sex couples were denied, so were some opposite-sex couples. And this is where you see the distinction between an indirect case and a direct case. Where there is some leakage between the two groups, you have an indirect claim. And at paragraph 23 and 25, I don't need to take you to it, but then she goes on to consider the position of civil partnerships as opposed simply to unmarried couples, and finds that civil partnership is essentially the same as marriage, and therefore when you say only married people can use the double-bedded room, you're saying effectively only heterosexual couples can. Lady Hale looked at two European Court of Justice cases, and they are relevant because the respondent has suggested that the law has taken something of a turn in this case. And I'm going to come back to those points in a moment, but for present purposes, I've just momentarily lost my place. The position that is clear from Preddy and Boll is that you have to have exact correspondence between the advantage and disadvantage groups, and we can see that from 21 where that doesn't exist in that case. As I said, for our purposes, the critical fact is that none of the advantage group are disadvantaged and vice versa. The EAT's reasons was for saying that there was not exact correspondence was that not all student members will be members of the IAA, and there's no evidence that IAA membership was limited to Indian nationals. But I've sought to demonstrate both of those facts are irrelevant because an Indian student has the opportunity to join the IAI. A British student never has that opportunity. And so far as whether there are other members of the IAI from other nationalities, again it's irrelevant because we're looking at a direct discrimination case which throws through the comparator groups who's advantaged and disadvantaged in the comparator groups.
But it does involve those who are capable of being advantaged, because if they so choose, they are A, Indian nationals, and B, will join the IAI to take 2 extra IAA or 2 IAA examinations. So you're applying this concept not to people who are potentially advantaged. And does that matter? Because if your question is what are the reason why the United Kingdom Institute is doing it, they would say, well, the answer is because we want people who've got equivalent exams recognised, and if you haven't got an equivalent exam, that's it. And if in fact that group includes Indian nationals because they haven't bothered to register, and they say, well, that's their choice, does that affect it, or are we back to what you were saying earlier?
We're back
that because potentially everyone can deal with it, or put differently, because you're only dealing with a situation where those who are Indian have gone and got the other exams which they want to exempt. That's enough.
Well, you're comparing yourself as and this is subject to ground 3, the comparative point, but you're comparing yourself as a British student member of the respondent with an Indian student member of the respondent. Not an Indian student member as the member of the IAI, because that would be, in a sense, self-defeating. You have to compare people in the material of the same circumstances. And what you're saying, you're sat next to your Indian colleague, you're saying he or she can go off to the IAI, get admission and take their exams. I can't do that. They have the opportunity to do that. I don't. So when you get to the end of the process, for those who've taken that opportunity, I can never do that, so it's not worth me starting because I can't get into the IAI to start with.
So you've got to redefine the treatment, or define the treatment more accurately. The treatment is the willingness to grant exemptions to people who take the IA exams. And once that is the treatment, you say, because the only people who can take the IA exams exclude British nationals, then there's discrimination.
Yes, that's
the way I think. Yeah.
And
That leads me back to the first question I asked. The only thing legally, leave aside your question of economic pressure, legally, the only thing the Institute can do at this stage, and maybe it doesn't matter, the only thing the Institute can do legally to prevent that situation occurring is to refuse to recognise the IA exams.
That's right. But it's in a sense the same as the swimming pool in Eastleigh. The only option it had was to change.
Well, the option there was to let people in. The men could go in for the cheaper price at 60. Here, your client can never use the Section 13 route to get 2 exams taken by the AAA recognised.
No, but he is entitled to say, and did say in the document, produced its remedy decision on this basis, that actually what would have happened in reality is...
No. I mean, it's tomorrow. He can't insist that he has the extra examination. And for example, he can't say he suffered economic loss in not having the qualification because he was excluded from the IA exams, because the Institute can't change that. The only thing they can do is say, this is unacceptable, we will not deal with you. Change your rules, we'll deal with you, but we won't deal with you now. So in terms of loss, it might mean you get your injury to feelings, but I wonder then how you can feed it into loss, and also whether that casts light on treatment by the Institute, if the only treatment it can bring about is not dealing rather than extending the advantage.
Well, we take issue, my lord, with that, because we say in the real world, in fact, what would have happened is they simply would have opened up the exams to British students, and that gives you the loss, because that is you would say plainly what would have happened, and that's the basis on which the loss was assessed in this case, and there's been no cross appeal in relation to that.
Sorry, my fault. Can I just make sure I've understood that? So you're saying, in the real world, if the IFA refused to recognise the IAI's exams, the IAI would then let British students take them?
Yes, if the choice was, we're not going to let your students register their exemptions.
Yeah.
Then at the time, I think the position may be different now, but at the time, that's what would have happened.
All right.
Well, how do we know that? You say the real world. I mean, goodness knows what the real world is like. We can only deal with the legal world. This is how A has treated B, not how it hopes, if it exercises pressure or if it persuades another person that it's economically in their interest.
Well, the position, like any discrimination, you claim you make the case as to what would or wouldn't have happened in the given circumstances once you've established liability. In this case, you would say, well, obviously, what would have happened is that there would have been a deal reached between the IAI and the IA.
I don't even know how we could even begin to. I mean, I don't know whether the Indian Institute takes the view that it provides a service for Indian nationals or not. We don't know anything about it. I don't see how we can speculate on that. The position legally is, if you are right, and that's what we're testing, because we don't know yet whether you're right. If you're right, it does seem to me at the moment that legally the only consequence that would result is that the system of exemptions is flawed because it's recognising exemptions from bodies that don't let British nationals join. And the only thing it can do legally to bring about an immediate change to that situation would be to stop recognising them. If the world changes and the IAA begins to recognise them, then maybe things will change. But legally, the only thing that the IAA Institute can do to prevent the discrimination and less favourable treatment that you've identified continuing is to remove it. They can't legally bring about a situation where the IAA provides exams for British nationals. So legally, the only thing they can do to prevent the differential treatment occurring is to refuse to give the exemptions to Indian nationals.
Well, I think there have been some developments on that front since. I'll take instructions.
But legally, that's correct, isn't it?
Well, yes, in terms of, but they've got no power to force. They've got the power of negotiation. That's where the power comes from. It's not,
yes, but that's not a legal thing.
No, it's not. No, it's no legal force. But that does that in a discrimination case, you look at what would have happened. You don't look at whether somebody has a legal obligation to do something. You say, well, what would they have done in practice? That's how the matter is dealt with normally. I'm conscious, my lords and my lady, of the time. I'll move quickly through. In fact, I was going to take you through the European cases of Bressel and Schnorbus, but I think, given the time, I won't. I'll see whether my learned friend proceeds on that point, and I may come back by way of reply on those, because we say that doesn't take the matter much further. Just finally picking up the case of Pat Malnice, which is an indirect discrimination case related to fairly complicated facts in relation to benefits for foreign residents. At page 206 of the authorities bundle, paragraph 91, the point I've already made on a few occasions is repeated, that as in James, in the Schnorbus case, there was an exact correspondence between the requirement of sex and the sex of those whom it advantaged or disadvantaged, as the case may be. In the Schnorbus case, and that was a case which was a case concerned with solicitors or lawyers training and exemptions to lawyers training, one of which was military service, for which only men were eligible. All men were advantaged and all women were disadvantaged. So in the James case, all men were advantaged, all women disadvantaged. In Bressel, that was a case in relation to Belgian nationality for students, or being able to be able to do student courses in Belgium. And Lady Hale took issue with the analysis of Advocate General Sharpston in that case. But the focus of my submission is on what she says in paragraph 91. Those are my submissions on exact correspondence grounds 2. Unless I can be of any further assistance, I'll move to ground 3, which I can take relatively shortly. The ground is that the Employment Appeals Tribunal erred in law in determining that the tribunal had erred in its identification of the comparator. At the Employment Tribunal, we say we're entitled to find the appropriate comparator was that relied on by the appellant, namely the Indian student member of R. This is in the Employment Appeal Tribunal's decision judgment at paragraph 51, page 69 of the core bundle.
Yes.
And you'll see that in the final sentence on that page, the finding that the tribunal erred in its identification of the comparator.
Yes.
I take this shortly. The hypothetical comparator in this case is an Indian student member of the respondent. It is not appropriate to say it's an Indian student member of the respondent who is also a member of the IAI, quite simply because there is a material difference then between the circumstances of that student and the British student. And that is prohibited by Section 23 of the Equality Act, which provides there must be no material difference between the circumstances of each case. So if you say the Indian student is also a member of the IAI, you're introducing a circumstance which is not present with the British student member. In any event, you can't include in the comparator the very issue which is relevant to the protected characteristic, in this case nationality. So when you're saying the Indian student is a member of the IAI, you're bringing into the comparator the challenge to the protected characteristic of nationality, because you can't join the IAI if you're British. So for those two reasons, we say the comparator is properly constructed and was properly arrived at by the tribunal. Now, ground 4 will take a little bit of time to work through. This is that the Employment Appeals Tribunal erred in law by setting aside the finding of the Employment Tribunal. There was an agreement between the respondent and the IAI that British nationals would not be permitted to join the IAI.
Before you get to the details of it, I haven't quite understood. You've appealed against the order dismissing Claim 1, the direct discrimination claim.
Yes.
I don't understand at the moment how ground 4 is material to that.
Well, ground 4 is relevant to that because although it's not central to the analysis of the direct discrimination case, it reinforces the finding that was made in relation to that, because it illuminates the reason for the treatment. If in fact there was it helps with the analysis. It's not essential to the analysis, but it helps with the analysis because the motive can help illuminate the reason for the treatment. So it reinforces the reason for the treatment if there was an existing agreement in place.
I haven't followed that, I'm afraid, and it's probably my fault. You appeal against an order, or a part of the order. The order you're appealing against is the order dismissing the direct discrimination claim. And you seem to agree in the first part of your response that that does not involve a determination of ground 4. And you're saying what precisely? That even though it's not something that's relevant to the dismissal of Claim 1, well, it helps because...
It helps because it illuminates the... Well, firstly for two reasons. Firstly, the EAT said it was relevant to all claims. That's why it appears, because the EAT held that this particular issue is relevant to all claims.
So they said the agreement was relevant to Claim 1?
Yes, they said the agreement was relevant to Claim 1. And it also helps in support of Claim 1, because if you have an agreement of this kind, it reinforces the reason for the treatment. So it's additional evidence in support of that.
Okay.
And we can see in the employment appeal decision that the issue of that I've just mentioned at paragraph 8, page 58, paragraph 9, page 58.
Yes.
the determination of the factual dispute was of considerable significance in all claims.
Sorry, where was that? I can't find it. 58.
Yes.
Paragraph 9.
Paragraph 9,
No,
page 50.
oh, page 58, sorry.
ET,
I beg your
ET.
pardon. My fault. Yep, okay, got it now.
So
Thank you.
that's why it features, but it also obviously has an effect on the remitted claims, because if this court were to determine that that finding of fact was properly made, then plainly it would have an impact on the remitted claims, even if this appeal was dismissed. If that fact was if that finding of fact was wrongly set aside by the EAT, it would plainly have an effect on the remitted claims, because this court would be overturning that particular finding of the EAT. And just to answer the question, well, you haven't appealed the other claims. We didn't appeal the other claims. We couldn't appeal on the basis that the EAT reached the right decision in remitting those claims back. But by the way, we'd like to deal with a particular finding of fact. That wouldn't be appropriate. You either appeal the decision to dismiss to uphold the appeal, or you don't, and we haven't, for reasons which go beyond this finding of fact. So it wasn't open to us to do that. And in respect of the criticism, I think the respondents make that we haven't appealed the remittal order. Well, the difficulty with that is that the remittal order itself, the order of the EAT, doesn't actually deal with the terms of the remittal. They're dealt with in the terms of the judgment, but they're not dealt with in the terms of the order. So the order itself is in the bundle, and that is, as I say, the remittal doesn't deal with that order. So it wasn't open to us to appeal the remittal order. The remittal simply says remit the claims to a fresh tribunal. It doesn't say on what terms. So, and finally, unless there was any doubt, of course, I did deal with this in the skeleton argument from which permission to appeal was granted. I made it clear in that skeleton argument that this would impact on other claims. So, just going back, if you'll allow me to proceed on my submissions on this ground, I'll do so. I'll start, if I may, with the relevant findings of the tribunal. And it's important to put this in context, that we start at paragraph 49. And I've taken you to this section. I'm just going to jump around a bit, but that is where the findings are made. But before I get to those findings, it's important to have regard to the following. This hearing took place, starts on the 14th of January 2019. About a month before then, a witness for the respondent, Mr. Bristow, and this is at paragraph 68 of the decision on page 100, contacted the IAI and put questions to him in an email. So there was contact with the IAI, and we know from the judgment, I won't take you to it, but paragraphs 52 and 53, there was contact with the IAI in 2010, 2017, and this ongoing commercial relationship, albeit at arm's length through a different subsidiary company, supplying materials. So what happened then was that the tribunal finished its submissions, finished with evidence of submissions on the 17th of January, and judgment was reserved. And then on the 13th of February, the respondent made an application to reopen the case because it had got from the IAI email traffic between the claimant and the IAI, some of which he disclosed, but there were additional emails which it was said he hadn't disclosed. So the original application was to reopen the hearing to deal with these two emails. The matter was then due to be listed in March, but the parties were unavailable. It came in May, 3rd of May. And a week before the hearing, the respondent produced a bundle which included in it extensive dealings with the IAI post the tribunal reserving its decision. And then we can pick that up in the tribunal's decision at paragraph 10. I just invite you to read paragraphs 10 through to 16. I won't read them out. If I could invite you to take a moment to read, you'll see how that application, what it involved and how it panned out.
Sorry, to which paragraph? 17?
16.
16.
So the application was made to get all this new material in. That application was refused.
Yes.
There was no appeal from that decision. And that's important because essentially this was evidence that the EAT have criticised the tribunal for saying there was the evidence it relied on, but it relied on the evidence that the parties chose to put before the tribunal. The respondent had ample opportunity to obtain that material before. And then, so if we then look at what the evidence that actually the finding is based on, the starting point is page 97, paragraph 49. And we can see this whole section deals with this. So it starts with the dealing with another student, Mr. Hirani, who was told in 2010 that he couldn't join the IAI because there was an agreement that in relation to the provision of study materials at low cost, it was necessary for the IAI to ensure that it did not compete with the respondent in specific terms, not to conduct examinations in the UK for UK residents and subjects. The 51, it's not in dispute there was an exam centre in the UK where IAI students could sit IAI exams and Indian student members could sit exams in the UK. The response from the IAA, paragraph 52, was copied to the educational director, Trevor Watkins, in 2013, and 53 we see Watkins corresponding, trying to understand the agreement and establishing there was no agreement, more of an understanding. 54, the claimant attempted to join the IAI in September 2017 and was told initially you're not a UK citizen, then pressed and was never told that he couldn't join because he was a UK citizen. They appeared to do some backtracking from the IAI, but nothing that ever said to him, no, you can join, we don't ban British citizens. And then all of these findings and documents, of course, were supplemented by oral evidence in the tribunal, where these respondents' witnesses were cross-examined on what they understood and what they knew and what they were aware of. And we see that, for example, 68 and 70, Mr. Bristow...
58, I'm just trying to follow what happened. So he wrote first of all, and Mr. Jane wrote back saying, you can't join, you're British. Then he asked, where's that in the rules? And it's not in the rules. And then 58, Mr. Jane said, you can take the asset examination and join the IAI. As I understand it, to do that, you've got to go to India. and that exam can only be taken in India. And then if he went to India and took that exam and passed it and became a member of the AII, then he could come back or could he?
Yes, he could, but the tribunal rejected that account.
Oh, right, okay.
Paragraph 76 and 77. So, having heard the evidence given by the respondent's witnesses as to what, and had considered all of the correspondences it was entitled to do, they reached a conclusion plainly open to it. Now, there's a dispute in this appeal between the...
how does 76, I'm just trying to work out, how does 76 fit with 58?
Well...
It says he was never told in terms that he could join as a UK citizen.
77, the tribunal concluded that if the IAI genuinely did not have a bar to UK citizens joining, it would have been very easy for the IAI to say this, either in answer to the claimant or in answer to the later application, or indeed in the answer to Mr. Bristow when he raised the matter in December. So they've covered off 3 different opportunities when they were being asked specifically about membership and so on, and have never said, actually,
So they haven't said that, and he doesn't explain there why he doesn't accept what Mr. James says, but that's in the next paragraph. He believes it was intentionally disingenuous,
Yes,
was it?
exactly.
Okay, so we've got to read all of that, yeah. Thanks.
And then, paragraph 80 on the evidence, the tribunal found the IA does have a policy of not allowing UK nationals to join it. That's the key finding. Now,
Based on what he's just recorded above.
Yes. There's a dispute in this appeal because our position is that the EAT only overturned the factual finding that there was an agreement or understanding with the IAI. It did not overturn the finding at paragraph 80 because our position is that that finding is still in place. And that's another reason, coming back to my Lord's point, why does this matter? Well, it matters because the respondent are now saying, actually, that finding has also been overturned, which obviously is fundamental to the discrimination, the direct discrimination claim. So, to work out how we got to where we are, it's then necessary to look.
So can you just remind me, where is the finding as to an agreement or understanding?
Paragraph 80.
80.
Sorry, forgive me, not the agreement, sorry, paragraph 72 and 73 for the agreement, for the actual...
Well, 72 and 73 seems to be discussing the evidence. The final conclusion seems to be in 80, that having looked at all of that, they don't believe that you can join it if you're British by joining the AC, taking the ACET exam. And the conclusion is, isn't it, the finding, that's why they use the word found, is that, and I'm deliberately avoiding the words in the first line, is that UK nationals can't join the IAI.
Yes, but there are, for example, you can see in different parts of the judgment at paragraph 154. You see reference to it there, and at 166, because it's relevant to claim 4 as well, so it's dealt with in more detail at 166.
I mean, they could have a policy without there being any understanding, I suppose. And
Yes,
is that your point?
That's my point, exactly. So we say the EAT have overturned the paragraph which says that there was an understanding, but left in place the policy. The two may not be entirely connected. I mean, obviously some connection between them, but it may not be entirely connected. So there's clear findings at 154, 166. Particularly 166, the tribunal has found there was an understanding between the Indian Institute and Liz Goodwin, Dr. Watkins' predecessor, will not admit British nationals. So there's no doubt that finding was made. And the EAT, as I say, dealt with this. But before I get to the EAT, it's first important to look at the respondent's grounds of appeal to the EAT to see if, let's see what was put in issue. The relevant passage is at 123, page 123 of the core bundle, right at the very foot, ground 9, and it's in the context of the section 112 claim, as this is where this arises. So there's a challenge in the second paragraph at the top of page 124. But the challenge is not to the fact of the understanding, but to the legal effect of that. There was no challenge before the EAT that that particular finding was perverse or should be set aside. What was challenged, and this was a successful challenge, that even if that was the case, it didn't mean there was a section 111 or section 112 claim made out. The next ground which is relied on by the respondent as raising the issue is ground 11, which are described as general grounds, presumably having general application to all claims. But that is focused on the less favourable treatment it said was perverse. But again, various points are made, but there's no challenge in clear terms to paragraph 80 of the decision. If you're going to say the tribunal wrongly found there was an agreement to exclude British nationals in paragraph 80 and that finding was perverse, you need to identify the paragraph and set out the reasons why. That has not been done. There's no suggestion in that paragraph that the focus of the paragraph is that the finding that there was an agreement in place was perverse. So then we look and see what the EAT did, the Employment Appeals Tribunal. I've started at paragraph, I think I've taken to paragraph 9 already, it's page,
Yes.
page 58. The next paragraph is paragraph 10, because this is the criticism we have of the Employment Appeals Tribunal's decision. And halfway down that paragraph, it talks about the application to adduce further evidence. It says this: a consequence of that decision, there was limited evidence about whether UK nationals are permitted to be members of the IAA and about the precise nature of any agreement or understanding between the respondent and the IAA at the relevant time. So it flags up at that point both issues. Then next, paragraph 27, dealing with the grounds of appeal of the respondent, which I've just looked at with you, is reference to ground 9 of the grounds of appeal, and the relevant part I've just read out, I've just taken you to. And it says, this ground 9b also asserts that the finding there was an agreement between the claimant and the IAI under which there was an absolute prohibition on British nationals joining the IAI was perverse. Well, that, with respect to the EAT, says no such thing. the ground of appeal was not that the finding was perverse. The ground of appeal was, if there was an understanding, it doesn't mean the section 111 or 112 claim is made out. Then, next, at paragraph 40, the EAT explain that they have significant concerns about the safety of the determination that there was an agreement between the respondent and the IAI that meant there was an absolute prohibition of a UK national being a member of the IAI because of the limited evidential basis for this finding, and particularly limited scope for the IAI to provide evidence in circumstances where it was not a party. Well, the respondent had every opportunity to obtain that evidence from the IAI, or in fact join the IAI if it so wished, or indeed get evidence directly from the IAI in the form of witness statement, which it did after the event. The point is then concluded at paragraph 64. And this is written before the parties make submissions on remission. This case may have to be remitted for redetermination, subject to submissions the parties have to make. This brings into focus my concerns about the factual finding that the respondent and the IA had an agreement under which there was an absolute prohibition on British nationals joining the IAI. So again, the focus of the EAT is on the agreement. And then we come at 66, so this is an important to look at the structure of this judgment. We're now in the disposal section, and in the disposal section at paragraph 70, it was agreed the section 112 claim should be remitted. There is a dispute as to whether on remission the question of whether there was an agreement between the respondent and the IAI would not be permitted to join the IAI will be open for fresh consideration. I accept the respondent's submission that finding was challenged in the appeal. Well, we say the EAT was wrong on that score, but be that as it may, it's clear that the EAT are only there concerned with the agreement and not with the underlying policy of the IAI. And as I repeat, paragraph 80 of the ET's decision, where that featured, was not appealed. Now, I can deal with the next part of my submissions very briefly. That this court will be very familiar when the Employment Appeals Tribunal is or is not entitled to interfere with the decision. It can only do so if there's no evidence to support a finding, or if the finding is perverse and there's full particulars set out, or it's a finding that no reasonable tribunal could have reached. The authorities are in the bundle. I won't take my lords and my lady to them. But here, we've seen the EAT went through in careful detail the finding in relation to the agreement. It reached proper conclusions having regard not just to the written evidence, but to the oral evidence that it heard. And it reached conclusions both as to the agreement, particularly paragraph 156, which was relevant to ground 4, more relevant to ground 4 than the other grounds, and also as to the policy of the IAI. The respondents criticised the claimant for not challenging the terms of the remission, but as I've said, the difficulty with that is that if one looks at the order of remission at page 53, one can see it's a very brief order on remission, and obviously there could be no challenge to the substantive claims where the claimant was accepting that in the case of the section 19 claim, the tribunal had not correctly identified the correct pool, and in the case of the section 112 claim, that it had not focused on the correct parties to and their roles in the decision making. So it had no basis for appealing either of those decisions. And as I said at the start of my submissions on this point, if one looks at the skeleton argument for the claimant for this appeal, at page 26, paragraph 6, it's clearly identified that ground 4 will impact on the remitted claims, claims 2 and 4, and in the same document, at paragraph 50, page 36, the challenge identifies the paragraphs in the EAT decision which are under challenge, paragraph 40, 64, and critically 70, which is the paragraph which states that the agreement, not the policy, would have to be revisited on a remittal. So drawing all of those threads together, it's the claimant's submission that the Employment Appeal Tribunal overstepped the mark in setting aside that clear finding of fact. And secondly, that the Employment Appeal Tribunal has not set aside the finding of the IAI's policy. If you're against me on the latter point, then I would seek permission to amend the ground of appeal to include that the Tribunal was wrong to also set aside, or the Employment Appeal Tribunal was also wrong to set aside the finding of fact as to the policy. Because there's no prejudice caused by that. The respondents have brought that point in by their skeleton. We don't accept it, but if we're wrong about it, it will be, we submit an injustice, not to deal with the matter on its merits, rather than some technical point in relation to the manner in which this appeal has been brought. But we say that our primary position is that they're wrong on that. Those are my submissions, unless I can give any further assistance.
Yeah. No, thank you very much. Yes, Mr. Reid.
Thank you, my lord. I wonder if I might just begin by a general observation that the thrust of this appeal is an attempt to shoehorn what's an indirect claim into a case argued to be direct discrimination. And that, I'm afraid to say, is evident by attempts to reformulate, recast and reinterpret the way it's argued. It's important always, though, to focus upon the case as presented and the issues determined in the judgment subject of the tribunal to appeal and the EAT consideration of that particular judgment. To do that, can I just take a step back? And to take a step back, can I remind you of the underlying jurisdiction that was being exercised by the Employment Tribunal? And that's at page 9 of the bundle of authorities. It's section 53 of the Equality Act 2010, qualification bodies. I just pause to note, it's a question asked by the court about status. For the purposes of your note and possibly in relation to judgment, my client is established by royal charter. It's a not-for-profit organisation, which obviously under the royal charter recognises the status of actuaries. And it's completely accepted, of course, that it is a qualification body. And the relevant section is section 53(1). A qualification body A must not discriminate, and we'll obviously note in a moment the relevant provisions in relation to that, against a person B in the arrangements A, the qualification body, makes for deciding upon whom to confer a relevant qualification, or B, and I think that's the only potential one which may be relevant in relation to this appeal, as to the terms on which it is prepared to confer a relevant qualification on B. So one is specifically concerned with the arrangements made by the qualification body itself, or the terms upon which it seeks or concludes to confer a qualification on an individual. And we start off with a fundamental problem then, which was identified in the EAT about the way the case was presented. And my learned friend took you to page 157 in the claim form, 157 in the core bundle. And that sets out various forms of claim. 2.11 is where we find the direct discrimination claim framed in these terms: allowing Indian students of the Institute of Actuaries 4 sittings per year to sit exams for the same qualification, whereas British IFO students are only permitted 2 sittings, results in direct, alternatively pleaded indirect race discrimination. And my learned friend points to later points in relation to that, but what one notes is there's no change in the way that that's presented when one looks at the articulation of it by the Employment Tribunal itself, because if you turn back to page 84, and paragraph 2, noting, as I've indicated, an acceptance that the claimant, that the respondent is a qualification body, under direct discrimination brackets nationality, we see the replication of that in this form. UK students are disadvantaged because Indian students have 4 opportunities per year to pass exams, and in 2018 5 opportunities, but I don't think we ever get concerned with that, and British students only have 2. So if you read that, the conclusion would be that the complaint is that the arrangements that are made, or the terms for conferment, to bring within section 53, are that the respondent allows Indian students to sit for examinations. And of course, if you look at the judgment, which is the subject of the appeal, at page 83, that's the way the judgment is articulated by the Employment Tribunal. The respondent directly discriminated against the claimant, a British national, because of race, in respect of the number of opportunities it gave him to pass examinations to qualify as a fellow of the respondent, compared to the number of opportunities it gave to Indian students. Well, when one pauses to think about, of course, that's completely unsustainable as a proposition, because the treatment that's actually being complained about there is not treatment in terms of the arrangements which the respondent makes, or the terms it's prepared to confer a relevant qualification. The treatment that's being complained about is treatment that the Indian, the IFA, chooses to allow examinations on dates which are different to those afforded by my client. That's the only reason there are 4. It's because the IFA, in its arrangements, allows 4. Allows 2 on different occasions.
Do you mean IAA?
I do apologise. I mean, yes.
Do you mean the IAI?
Yes. So that's a treatment, and of course, at its central point, that is really the claimant's complaint, that body, and we have a second line of complaint, which is exclusion from membership, but if that body aligned its examinations with the examinations of the respondent, the entire complaint of direct discrimination, even on the claimant's best case, would disappear. And that really only serves to underline that the treatment that is the centre of the complaint for direct discrimination is not treatment afforded by the respondent.
There could be three things. One could be the arrangements for the date of the exam. That's one thing. The second could be the arrangements by which people are allowed to become a member of a foreign body, the Indian Institute, which allows you to take exams. The third arrangement or term could be the arrangements under which you recognise examinations taken by a foreign body. And the third could be a direct discrimination.
Can I come? I can deal with that straight away because so noting that's not the judgment that's the subject of the Employment Tribunal decision, and that's really where the EAT pick up. I take your point to say, but the difficulty is, what's the treatment one's looking at? If you take your third example, the treatment is we decide to recognise examinations of other actuarial bodies which we regard as being of sufficient difficulty to equate to our own qualification. So it's important to identify that as a treatment. Now, I agree that if that treatment were directly aligned in a James way to a protected characteristic, there would be an issue. But that isn't the case. What we see at 45, and remembering, and it's a point your Lordship made to my own friend, 45 in the Employment Tribunal judgment, when one looks at that, one has to look at the actual arrangements that the respondent makes, which is to recognise equivalent qualifications from other bodies. At paragraph 45 in the tribunal judgment, it's page 96.
Sorry.
96 core bundle, ET decision, paragraph 45.
Sorry, I thought we were going to the employment appeal, so I got wrong. Yes. 45 of the ET.
ET.
Yes.
And and what we note there is that in terms of the respondent's approach, it recognises exemptions from a variety of different bodies, although if you note the last sentence, from some examinations, from some actuarial bodies, there are less exemptions recognised than others, because its decision making is not about the body, it's about the standard of the examination qualification and whether or not that is sufficient to equate it to an exemption from its own examination. Now, going back to your Lordship's question, if my clients had taken the approach, we will allow anyone who's a member of the Indian Institute immediately to become a fellow. There might be an argument to say that that equates to a protected characteristic if it was made out that that was the case, that that was directly excluding UK non-nationals. But that's a step away. He has to have a situation where he relies upon admission being excluded from a UK national, detrimental treatment by the Indian body. He relies upon the effect of, note the effect of, them allowing 2 exam periods in relation to the exams other than on dates for those by my client. But all of that is a step back from the decision. The decision about the arrangements for recognising qualifications is based on equivalence of standard. Can he say that the decision based on equivalent standards in exams is equated with protected characteristic? Well, there's no evidence to show that it is, other than if he constrains a narrow interpretation by introducing factors which aren't part of the decision. Well, that's all about indirect effect. As my Lord Justice Lewis put to my late friend, if he was going to run that, we'd really have to look at the ethnic composition by way of protected characteristics of all of the people who'd been recognised as being eligible from qualifications across the world and see whether or not that indicated a direct correlation between protected characteristic and that decision. And the problem, as I say, is it's a displaced decision, because the decision quite clearly is about the exam. And that's really the key distinction with a case like James. Because when you look at a case like James, and I don't need to trouble with subsequent authorities, we can focus on James itself. If you look at James, the decision that the swimming pool was making was to say, we will charge you less if you're a woman because of retirement age. Well, that directly linked to a factor that was immediately exactly aligned with gender, because retirement age and gender were linked together. If you compare the decision here, we recognise exams which have been passed by under the Indian body because they are of equivalence. That is not directly aligned to gender. No question that this could be a case of indirect discrimination. We don't accept that it is, but no question that it could be argued in that. But to try and squeeze it into direct discrimination, whether by reframing it as being the recognition of other exams, as my learned friend attempts to at this appellant level, the original tribunal judgment being quite different, still doesn't help him, because it doesn't get you to a James situation once you realise that the key point for the legislation is what's the decision about recognition of qualifications. It's clear that it's about equivalence of standard.
Is that a convenient moment?
It is.
Right, thank you. We'll start again at 2 o'clock. How long do you think it'll be? Just a rough indication.
40 minutes. I'm not going to. To be honest, you have my clear point on direct discrimination. Repetition I find to be less helpful. I'm going to deal with other points.
Okay, thank you.
Court rise at table.